Hello viewers, welcome to Ekam Academy. Today we are going to discuss about Article 22 of Indian Constitution, which guarantees certain fundamental rights in situations of arrest and detention. So what did recent Supreme Court remark regarding Article 22 of Indian Constitution, and all other related provisions of Article 22 we'll understand in this particular video. Right. So first thing, we'll understand the recent context first. Article 22. So recently Supreme Court said the reasons behind arrest of any person in the situation of arrest or detention need to be disclosed for sure. That means mandatorily a person who is getting arrested has to be disclosed the grounds of arrest. So it's not like optional or provisional. It is very much important to disclose, and it is a mandatory provision. If it is not being done, then it's a clear violation of Article 22 and Article 21, which is also ensuring right to personal liberty and right to life. That is what the recent Supreme Court remark with respect to Article 22. First, let us understand what is this provision of Article 22. It guarantees rights against certain arrests and detentions. That means a person who is getting arrested or detained is going to have certain freedoms guaranteed under Article 22. Those have to be upheld in any situation, right? So then, what is the purpose of granting this? So this is to prevent any miscarriage of justice. Right? Any miscarriage of justice have to be prevented, and the persons who can detain or the authorities who can detain, like police or any other official, and they cannot actually resort to any like you can say any misuse of power, or checks and balances have to be ensured on them so that they are not going to misuse the power they have with respect to arrest and detention. So these are the main purposes behind Article 22 in the Indian Constitution. Then when you see the applicability and availability, so this is applicable to all persons generally. All persons here I mean, so it is applied even to citizens and foreigners also. But there is a catch here. So in the foreigners also, to enemy aliens generally, this provisions of Article 22 doesn't apply. It doesn't apply to enemy alien. Enemy alien is a foreigner of a country whom India doesn't have good relations, right? So for example, we consider our neighboring countries with whom we don't have cordial relations. Those country persons will be considered as enemy aliens to India. For them, the Article 22 related provisions doesn't apply. But for friendly aliens and for all the citizens of India, these provisions will apply. Then it will be applicable to the cases where they have criminal nature or quasi-criminal nature. So it is applied for all the cases where there is some criminal nature and quasi-criminal nature applied. So it doesn't apply to the cases where there is some civil elements involved. At the same time, we also have to remember this is applied to all the cases. Okay, all the cases related to arrest and detention, but it is not applied to the cases where warrant is issued by the court. Generally, when court issues the warrant, okay, so at that point of time, this related provisions of Article 22 will not apply, but in all other situations they will apply, right? Then we'll understand the 7 sub-provisions of Article 22. So first, Article 22 Clause 1 says that there has to be some reasons, and the reasons behind arrest. Okay, so reasons of arrest have to be clearly communicated to the person who is getting arrested. At the same time, he also have a right to consult legal practitioner. So to represent him before the court, he has a right to consult the legal practitioner. That is Article 22 Clause 1. Then Article 22 Clause 2 says the arrested person have to be produced before magistrate within 24 hours of arrest. Right? So this 24 hours of arrest is excluding journey time, right? So you have to be produced before the magistrate within 24 hours, excluding journey time. Journey time from the place of arrest to the magistrate's place, right? Then we also have to understand after 24 hours, if the magistrate doesn't order further detention or further custody, then the person is set free, right? That means if the magistrate doesn't order further arrest or detention, then the person can walk free. That is what Article 22 Clause 2 also talks about. Then Article 22 Clause 3 gives some exceptions. As we have seen, the provisions related to Article 22 Clause 3 doesn't apply to enemy alien, and the persons who got arrested under preventive detention law, right? So what is this preventive detention law? When we talk about Article 22, we have to remember 2 types of detentions can happen. One is punitive detention, another one is preventive detention, right? Punitive detention and preventive detention. So when you talk about punitive detention, so this is after committing some offense, if a person is considered as like a person guilty by the court, then whatever the offense that is given, that comes under punitive detention. Then preventive detention is the person, before doing any particular act, on the apprehension that that person might have done or might do that particular act, will detain the persons before only. This is after commission of a particular crime, but this is before. So this is what preventive detention law. That means any person who is getting arrested under preventive detention law cannot exercise the fundamental rights of Article 22 Clause 1 and 22 Clause 2. Right? Then Article 22 Clause 4 talks about a person who is detained under preventive detention cannot be detained for more than 3 months of time. So not more than 3 months of time, until unless the advisory board which is constituted will further say that the person has to be detained, then only he can be detained for a period more than 3 months on a situation. Right? Then Article 22 Clause 5. So this talks about the reasons that has to be communicated. Okay, reasons have to be communicated if a person is arrested under preventive detention law, right? So what we have discussed under Article 22 Clause 1 talks about the punitive detention. Under 22 Clause 5, the reasons for a person who is arrested under preventive detention or clearly have to be communicated. Then Article 22 Clause 6 talks about a person who is arrested under preventive detention if the reasons are in the interest of public. For example, if a person is arrested on the grounds of terrorism, so then the reasons behind his arrest can create some like fear and anxiety and all these things among the public, or it may endanger the national security also. In that situation, it is not mandatory to disclose the grounds of arrest also. This is exception which is applied for preventive detention related provisions. Then Article 22 Clause 7. So this empowers Parliament. Okay, Parliament has a provision, or you can have the power to make laws with respect to under what circumstances you can arrest a person under preventive detention law. Okay, so circumstances for arrest under preventive detention law is one thing which is having under the Parliament domain. At the same time, the time. Okay, so the 3 months of time can be extended or further things can be changed with the consent of the Parliament by law. So these are the provisions mentioned from Article 22 Clause 1 to 22 Clause 7. Now let us see the practice question in this regard. Preventive detention under Article 22 allows the government to detain a person without trial for a maximum period of how many months until extended by advisory board. So I have already discussed the related provision. So if you're sure, let me know in the comment section. Then today we have discussed about Article 22, why recently Supreme Court made a remark regarding Article 22, related provisions of Article 22, applicability and availability, and all other rights related to Article 22. So if you like the video, let us know in the comment section. Thanks for joining. All the very best.